Is the sex offender registry a form of punishment? Black's Law Dictionary, 6th edition, defines punishment as any fine, penalty, or confinement inflicted upon a person by the authority of the law, and the judgment and sentence of a court for some crime or offense committed by him, or for his omission of a duty enjoined by law. When a person is charged with a crime, in most cases, a single event becomes many charges. This is a tactic known as charge stacking, and is frequently used by district attorneys and prosecutors as a way of extracting the greatest amount of punishment from a single event. In every criminal case, the district attorney or the prosecutor will reserve one charge out of the laundry list of charges for probation. The reason why they have to do this is due to the fact that probation is considered a form of punishment, primarily because the accused must pay for their probation fees out of their own pocket, is considered a type of fine, and because it is illegal to be punished twice for the same offense in the United States. Sex offender registration, on the other hand, was ruled not to be a form of punishment by the U.S. Supreme Court in Connecticut Department of Public Safety versus Doe, 538 U.S. 1, in the year 2003, and can therefore be freely applied. But is it really true that the sex offender registry is not a form of punishment? To answer this question, it is necessary to first identify what the law demands of a person on the sex offender registry, and it is important to remember that many changes to registry laws have taken effect since the U.S. Supreme Court heard this case, and that the laws have become more stringent since then. The requirements of the sex offender registry of the various states is not consistent. Some states have more stringent requirements than others, but for the purpose of this video, we will use the sex offender registry requirements of the state of Arizona. In Arizona, the offender must provide all names by which he is known, his mailing address, his physical residence, fingerprints, photograph, any required online identifiers. Must notify law enforcement within 72 hours of any move or change of name. ARS 13-3822A and B. A move requires notification to sheriffs in both the original county and the destination county. Each must be informed in writing, and the letter must also be informed in person. An offender who studies or works at an institution of post-secondary education must initially notify the county sheriff of that jurisdiction and keep him informed of any changes in enrollment or employment status. A transient offender must register with the local sheriff every 90 days. ARS 13-3822A. If an offender changes a required online identifier, he must notify the sheriff within 72 hours and before using the identifier. ARS 13-3822C. An offender who fails to register is guilty of a Class 6 felony, and a registrant who does not keep his information updated is guilty of a Class 4 felony, ARS 13-3824. These offenses carry respectively 1 year and 2.5 year presumptive prison sentences for first-time offenders, ARS 13-701C. For a Level 2 or 3 offender, the offender's name, address, age, current photograph, conviction, and risk assessment level appear on the sex offender website, ARS 13-3827 A and B and 3826 E1A. For Level 1 offenders, law enforcement may notify the people with whom the offender resides, ARS 13-3826 E1B. For offenders who are students or employees of post-secondary education institutions, law enforcement must notify the administration of the institution and, in some instances, the campus community, ARS 13-3825G. The Department of Public Safety may also communicate with businesses and organizations that offer electronic communication services about whether an offender's online identifier is being used on their systems, ARS 13-3827E. A violation of any of the above requirements is a Class 4 felony, ARS 13-3824, and is considered a new charge punishable by a prison term of 1 to 15 years, ARS 13-703. It is important to remember that these requirements must be met for the rest of a person's life. There is no recognition for good behavior, and there are no legal provisions in most state law for being removed from the registry. When a person is released from prison after serving a sentence for any crime other than a sex offense, their debt to society is considered paid in full, and no further requirements other than probation are imposed upon them. However, a sex offender is required by law to register his name, address, photograph, and fingerprints with local law enforcement everywhere he or she goes. No free man is required to register their name and address with law enforcement. Therefore, sex offender registration is the imposition of a penalty, and as such is a form of punishment. No other form of crime carries this requirement, even murder. This condition is a statement that the public fears living next to a sex offender more than someone who might kill them. This overlooks the fact that rape is something that you can overcome, whereas death is forever and only serves to illustrate how irrational and blown out of proportion this situation is.